Welcome to Constangy Clips, the series with tips on staying ahead of important legal challenges in the workplace and cyberspace. My name is Alexis Holloway, and I'm an associate attorney in Constangy's Winston-Salem, North Carolina office. Today, I'm going to talk about the most important developments from this year at the Equal Employment Opportunity Commission and what your organization can do to stay compliant. With the change of presidential administrations at the beginning of the year, labor and employment law is also changing. The EEOC enforces federal laws that make it illegal to discriminate against an employee because of race, color, religion, national origin, age, disability, genetic information, or sex. And sex includes not just male-female, but also pregnancy and related conditions, gender identity, and sexual orientation. Here are some of the biggest changes to the EEOC since President Trump took office. First, the EEOC has undergone an organizational shakeup. Shortly after he took office, President Trump fired 2 Democratic EEOC commissioners. As a result, the 5-member commission had 3 vacant seats, and the remaining commissioners were 1 Republican and 1 Democrat. The president's action also left the EEOC without a quorum and prevented it from making significant decisions or taking formal action. But in October, the Senate confirmed a new commissioner, a Republican, which restored the quorum and created a Republican majority. The EEOC can now resume its full range of enforcement and policy-setting activities. President Trump has also recently nominated Carter Crow of Texas to be the EEOC's general counsel. Mr. Crow is the head of the Employment and Labor Practice Group of a large international law firm, and he represents employers. The General Counsel oversees the EEOC's litigation efforts consistent with the agency's priorities. Which brings us to our next topic. The EEOC has shifted its enforcement priorities. The new chair of the EEOC is Republican Andrea Lucas, who was initially appointed to the EEOC during President Trump's first term. Chair Lucas has shared what she considers the agency's priorities: rooting out unlawful race and sex discrimination related to diversity, equity, and inclusion programs, targeting anti-American national origin discrimination, defending the biological and binary reality of sex, and protecting workers from religious bias and harassment based on religion. We are likely to see more aggressive EEOC enforcement in these areas and possibly less aggressive enforcement in the areas of transgender rights. This could include cases involving single-sex facilities as well as pronoun policies. Also consistent with an executive order issued by President Trump in April, we expect the EEOC to de-emphasize, if not completely decline to pursue, cases based on alleged disparate impact discrimination. This exists when an employer has a neutral policy that disproportionately affects individuals in a particular protected group. So, what should employers do to stay compliant? In light of these developments, organizations should make sure that, in addition to their regular anti-discrimination efforts, they monitor and make appropriate changes in these areas. DEI. Employers must not engage in so-called reverse discrimination to achieve a more diverse workforce. You should always hire the most qualified candidate based on skill or merit. That said, it is lawful to cast a wide net when recruiting for positions to ensure a diverse pool of qualified applicants. American discrimination. Employers should not discriminate against applicants or employees based on national origin, and that includes discrimination because the applicant or employee is American. All national origins are protected categories. Gender identity. Employers should not tolerate discrimination or harassment based on gender identity. They should allow transgender employees to dress and groom at work consistent with their gender identities and encourage employees to address transgender employees by their preferred names and pronouns. However, if an employee has a religious objection to using preferred names and pronouns, the employer should be open to considering reasonable accommodations. Religion. Educate your employees on religious freedom and be receptive to requests for religious accommodation. We expect the current EEOC to be especially conscious of the religious rights of Christian and Jewish employees. By understanding these EEOC developments and adjusting your policies accordingly, your organization can stay ahead of enforcement trends and reduce legal risk. Staying proactive ensures that your workplace remains compliant while fostering a fair and equitable environment for all employees. Thank you for watching. Be sure to follow Constangy on LinkedIn, Facebook, and YouTube for important updates and more tips for minimizing your legal risk.